Next up on This Week in Law, I'm Denise Howell, and I'm joined by Nate Cardozo from the EFF, also Stefan Schweida and Matt Curtis. We'll talk about the day against DRM, liability for acts on your Wi-Fi network, the Music Modernization Act, federal preemption of California's new privacy and net neutrality laws, and having better encryption than Michael Cohen and Paul Manafort. All next here on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
This is TWiL, This Week in Law with Denise Howell, Matt Curtis, and Stefan Schweida. Episode 435, recorded September 21st, 2018. Goliath versus Ant-Man. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. We're so excited to be here with you this week. We've got an amazing return guest to the show. We were just reminiscing that we cannot believe it's been 3 years since Nate Cardozo has joined us, but it has, and we're thrilled to have him back. Nate is a senior staff attorney at EFF. Hello, Nate. Great to see you.
Hey, Denise. Good to see you, too.
Welcome back. We're going to have to do better about, these 3-year gaps. That's just far too much to hear from you.
Yeah, I'll be on more often. Don't worry.
Okay, thank you very much. We appreciate that. Also, here are my two wonderful co-hosts. Stefan Schweida is here. He's a lawyer at the Dorsey & Whitney firm in Seattle, Washington. Hi, Stefan.
Hi, Denise. Hey, Nate. Looking forward to learning from you today.
Great to see you, Stefan. Also with us is Matt Curtis. Hi, Matt. Great to see you.
Great to see everybody, too. And Nate, excited to have you on.
Thanks a lot.
All right, well, let's jump right into it. There's been lots going on. Let's start with some developments on the copyright front. There was a pretty interesting case out of the Ninth Circuit that involved, of all things, Adam Sandler's his film, The Cobbler. And it is good news for everyone who has Wi-Fi in their home, or in this particular instance, the circumstance, the premises in question were an adult care home. So what went on here was Cobbler, Nevada is the rights holder for this movie, The Cobbler. And they decided that someone was pirating this film. And they went to the ISP in question and obtained the name of the subscriber where they believed the illegal, unauthorized download and or streaming had taken place. And they went to, they filed a lawsuit. They named as the defendant the internet service provider's subscriber. And that person came into court and filed a motion to dismiss the lawsuit and won it. And that is what was affirmed on appeal by the Ninth Circuit. The Ninth Circuit agreed that the rights holder here didn't even have a claim to assert because they tried to assert both direct infringement and contributory infringement, which would be the subscriber himself did not download or infringe, but someone using his internet access did. And this is something that we've always sort of wrung our hands about. How responsible do you have to be about people using the internet service that you are providing them with as a subscriber to an ISP. And this case seems pretty clear that there was going to be no direct infringement on the part of the subscriber. The plaintiff could not establish that that was the infringer, and that they further couldn't hold him contributorily liable for the infringement of someone on the network. What would have had to happen here, I guess, is they would have had to figure out who that potential infringer was and go after that particular person as the defendant. So this is a reaffirmation of Supreme Court precedent in Grokster in the way the contributory infringement doctrine is to be applied. And it's sort of a sigh of relief, I think, for everyone, whether you're operating an adult care home or not, whether you're simply having people use your own home internet. It's good news that if they're doing something they shouldn't be, you as the internet service provider subscriber have good arguments that you shouldn't be involved in any lawsuits over that. So any thoughts about this, Nate?
Yeah, I've got a couple of different thoughts. The first is this is just obvious that this ruling should come across to an informed reader as mind-numbingly obvious. And I'll draw a real-world example here. Denise, if I lent you my car and you went out and mowed a bunch of pedestrians down, there's no way that I would be liable for that. And I wouldn't be liable civilly. I wouldn't be liable for criminal charges because I didn't have the intent to do it. Now, if I lent you my car and said, here, take this car and go mow down some pedestrians, that would be a different story. Or if you said, hey, can I borrow your car to go run down some pedestrians? Again, it'd be a different story. But if you just took my car, you said, hey, can I borrow your car? And I said, sure, here it is. You're liable for what you do with it and not me. So that's number one, that this is just a really obvious kind of ruling. I run an open wireless network at my house. I have my own network, and then I have my router set up for a guest network. I shouldn't be liable for my next door neighbor or my weekend guest who does X, Y, or Z using my internet connection. Now, the second reason why I think this ruling is notable isn't obvious at all. And it's this. At EFF, we have for a long time been working on the criminal law side to try and get courts to recognize that an IP address is not a perfect proxy and often not even a very good proxy for identity, and that a warrant affidavit, an affidavit in support of an application for a search warrant, needs to show more than a bare IP address in order to show probable cause. Obviously, this ruling from the Ninth Circuit is in copyright, completely different standards than criminal. But you can bet your bottom dollar that we're going to take this ruling and throw it back in the prosecutors' faces when they try and get a search warrant based on nothing more than an IP address, which is essentially what Cobbler, Nevada tried to do here. Is they tried to get or defeat a motion to dismiss, which is obviously a different standard than probable cause, but based on a bare IP address being a perfect proxy for identity. That's obviously not true. And now we have a solid Ninth Circuit case describing why in the copyright context, it's definitely not true.
Yeah, that's a really interesting twist on this that I had not thought about. So even though it's not a perfect analogy, right? Because you have the ISP saying we have a subscriber who lives at this address that matches that IP address. That's a little bit closer proxy, at least to know that's where our subscriber is. We don't know that our subscriber was doing anything wrong, but if you'd like to try and prove that in court, have at it.
Indeed, the sorts of things that we think that judges should be requiring prosecutors to get before they get a search warrant based on a similar set of facts is like, do a drive-by. Is the network secured? Look into who lives in the house. Is it a 97-year-old grandmother living alone who just never secured her Wi-Fi? Right? Police, generally speaking, have not done those sorts of basic background research before they get a search warrant and bust down a subscriber's door. And so we're going to use this to say an IP address plus a little something more is necessary for a search warrant.
Got it. What do you think, Stefan?
I have a question for Nate on the particular facts here and whether he thinks that the fact that this was, it looks like it was several adults who weren't related living in the same house. That was kind of a business/house, I think it's fair to characterize it. Do you think that was relevant to the outcome? In other words, if this were a traditional family home with parents and children, and the children were alleged to have been downloading the movies. Could the parents have escaped liability under the same theory, or was there something particular about the arrangement in this house that made it extra difficult for the parties to plead infringement here?
There's definitely something particular about the facts here that made it hard for Cobbler, Nevada to prove infringement. As you say, unrelated adults living together in a house is definitely the not the most common situation for a residential internet subscriber. However, it's not all that uncommon either. So it's the facts here are obviously helped the case, but I don't think they're particularly out of the ordinary.
And the court, maybe this is just dicta, but the court did seem to want to lump in the private home situation as well. Here's a quote from the decision. They said that the theory of liability both strays from precedent and effectively creates an affirmative duty for private internet subscribers to monitor their internet service for infringement. And then it went on to say, imposing such a duty would put at risk any purchaser or internet service who shares access with a family member or roommate who is not technologically savvy enough to secure the connection to block access by a frugal neighbor. So it does seem like the court wanted this to be clear that they weren't particularly focused on the fact that this was a business relationship going on in this house.
That's right. And I think it's also the sort of situation that the court is describing where there is an affirmative duty to monitor for infringement. That's the way it works in most EU countries. For instance, in Germany, finding an open wireless network, an unsecured wireless network is essentially impossible because no one runs it, because you are liable for what strangers do on your network in Germany. And I think the Ninth Circuit, their clerks at least might be aware of that fact and crafted this opinion to avoid that kind of situation in the United States.
So I was saying before this decision came down, I would have been, more concerned that the German liability model might apply here. And again, it's just one federal circuit court. There could develop a split somewhere, I suppose. But do you think, Nate, that we're moving toward a regime in the United States that differs from the German one?
Absolutely. We've always had it. It's never been illegal to run an open wireless network. In the United States, their liability just simply doesn't attach. So I think this is, putting a stake in the ground to prevent us moving towards a German model.
Okay. Matt, any thoughts?
Yeah, and I think that the fact that they knocked this out on the pleadings and awarded attorney fees for the defendant, goes to that they want district courts to rule that in a similar set of facts that this doesn't go up on, a more factual determination. But as a matter of law, if there's multiple people living in the house, you have to assert that one of them, you have reason to believe or proof that one of them was actually doing the copyright infringement. So that all makes sense.
So before we leave this, let's just kind of explore the parameters of it a bit. You mentioned, Nate, that if I were borrowing your car and stated my intent to go mow down pedestrians, or you otherwise had some reason to believe that I might go do that, then your liability might be more in question, in addition to, of course, my own. How do you think that plays out in the context of sharing internet access with others?
So I can imagine a hypothetical case where I'm running a coffee shop here in San Francisco, and I say free Wi-Fi, and I put my SSID out, and then I put up a sign next to it that says, "We don't block BitTorrent, we don't block file sharing, we won't report you. Go nuts." I think in that set of facts, the coffee shop owner may well be liable for contributory infringement, but obviously that wasn't the set of facts that we had here.
Right. Okay. And how do you think it plays out since you hope to use this in your arsenal on the criminal law subpoena front? How do you think it plays out there?
I have a meeting set on Monday with my colleagues to plot, and I'm not going to tip my hand about what we're plotting quite yet.
Got it. All right. We wouldn't want to derail you guys. All right, then.
There might be prosecutors listening right now. I wouldn't want to.
No, but I guess what I'm asking is, again, it would be, I suppose, certainly a crime, vehicular manslaughter, if I were to go out and say, hey, Nate, I'm taking your car and I'm going to mow down some folks. Do you think that you would need that kind of sort of plotting and communication between two people for there to be a criminal liability for sharing internet access?
Oh, absolutely. It has to be shared intent.
Yeah. That's what I was driving at. Okay. Then let us look at an event, or mark an event that happened this week. September 18th was a day against DRM, digital rights management. Cory Doctorow posted an essay at EFF on this topic. I kind of just wanted to talk through with you, Nate, the state of DRM as we see it today. It looks far different than it did when we first started talking about DRM in law and policy circles, and we were talking before the show. I had my answering machine was recording something downstairs, and these guys all were going, "You have an answering machine?" Because yes, that's how old I am, and that's how that's how far back my memory of DRM goes. It's a whole different landscape now than the answering machine days. Back then, DRM was something that you had on a CD or a DVD and maybe on a garage door opener, right? And then we've had it on printers, and now we have it on just about everything, but I think it's less apparent. I think people don't realize as much as they used to. It's not impeding them, perhaps, the way that it used to. Do you agree with that assessment, Nate?
I do in some ways, and I don't in others. So one of, it used to be that DRM was most apparent attached to audio or video files that you downloaded, or software like games or operating systems. Nowadays, DRM is used really for different things. Apple abandoned DRM on iTunes downloads years and years ago, and you can just share those files without having to authorize another computer or anything like that. However, DRM has become much, much more important in the streaming world. Spotify, Pandora, iTunes Music, like Apple Music service, all of those are DRM. Netflix, Hulu, Amazon, all of those are DRM'd up one side and down the other. Of course, that hasn't stopped anyone really from pirating music or movies or software. It just raises a little bit of a bar. The other area where DRM has become ubiquitous in our lives that we might not think of it in the same way in the mobile market. This device has DRM on it. I'm holding my iPhone for those of you who can't see me. But it's not DRM in the same way that we thought about it. It's DRM to protect the security of the device rather than protect from copying, and it just has protecting from copying as sort of an incidental feature rather than the number one design goal of DRM. And I think it's important for us to look at the two of those types of DRM in analytically distinct ways. When Cory uses DRM, for instance, in the article he posted at EFF this week, he means the sort of DRM that protects media files, the sort of DRM that the DMCA was written to protect. That sort of DRM in the streaming world, it really doesn't look like is going anywhere. It looks like it's here to stay. And part of that is the content holders require media companies like Amazon, Netflix, or Spotify to apply DRM to a stream. They're just terrified of a bit-for-bit copy getting out there. That said, there are lossy copies that are still available. So, the DRM battle in some ways has been won, doesn't exist for downloads anymore. In some ways has been lost. It's ubiquitous in streaming. And in some ways, it's become a completely different conversation altogether because, for instance, on iOS and Android, it's not about copy protection. It's about security. And so I think we have to look at it very differently. So we've won, we've lost, and we've moved on all at the same time.
Yeah, that sounds about right. And just to clarify, when you said it doesn't exist for downloads anymore, you're talking about music specifically, correct?
Music, that's right. Video is still heavily encumbered by DRM.
Right.
It's only a matter of time, though, before it seems like the industry is moving towards it's only a matter of time before there is no such thing as a download and that everything is streaming, which would mean that we would have lost entirely, because if there's no downloads and everything is streaming, then everything will be DRM'd and we won't actually own anything anymore.
Yeah. Do you see that happening?
Yep, absolutely. We feared that was actually one of the reasons why Apple, for instance, did away with the headphone jack on phones, is to try and start slowly closing the analog hole to make DRM even stronger.
It seems though for that business model to work, you really have to have perfect, fast internet access everywhere. And indeed, yeah. Which is not the world we live in today. Right. I wonder if it will ever be. There will be places where people want to go that, wander where the Wi-Fi is weak, where simply, part of the appeal of the place is there's no internet access, and
Indeed,
yet you might want to bring music along with you.
And that's part of the reason why we're so opposed to everything being DRM'd and not actually owning our own media anymore.
Yeah. Stefan, any thoughts?
I had a question from EFF's perspective. Is there a difference on the content sort of media file side between DRM protection for download files and streaming files? Are they the policy justifications for combating them are the same?
Yeah, we don't really see an analytical distinction.
Matt, what do you think? Oh, go ahead, Stefan.
The follow-up question was going to be: do those who argue for the DRM see an analytical distinction, and if so, what have they articulated?
I haven't heard anything along those lines, but I don't know.
All right, Matt, any thoughts on the day against DRM or the state of DRM in our current world?
Yeah, so I guess the question is. If we're saying that DRM is bad in a streaming context, but we're largely entering a world, and this the flip side, the downside of this is that it's mostly reliant on using our information about us to sell advertising for us to be able to pay for free streaming. But a lot of people, because of the streaming services, have been able to access music that they wouldn't have been able to access for much more cheaply, and therefore have been able to access more content because of the switch to streaming, especially for those who weren't going to break copyright laws and use BitTorrent or something like that to get illegal copies. So for those individuals who would have been following the law before, they actually have more access because of an online streaming in DRM. Is there any sort of look into that and saying that, because we've moved to streaming, yes, the downside is that you have to basically pay to not get advertised to, and you're still, your privacy still being stolen essentially by using this. But is the world better or brighter because of the technological change?
I don't know if that framing is entirely right. YouTube has been where people go for music for a long time, and YouTube has been free. My wife used to work at Pandora. She now works at Pinterest. When she worked at Pandora, everyone would say, "Aren't you worried about Spotify?" And their answer was always, "No, Spotify is not a competitor. The competitor is YouTube." So putting streaming, I think has made paid access to a bunch of music possible, maybe easier access to a bunch of music possible. But we were already living in that world since 2006 when YouTube premiered.
Virgil in IRC has a great comment. He says, streaming is like a rental agreement for an apartment from which you can be evicted at any time for whatever reason.
Yeah, that's right.
Yeah, he's got a point. And Chumley in IRC is wondering why we're not discussing net neutrality in the context of this discussion about DRM and moving toward a world where everything streams. I mean, the point would be, yes, it's more important than ever for people to be able to access the media that they are subscribed to or otherwise authorized to access without being choked and throttled by their provider. I think that's the point to be made there. But anything you would add, Nate?
No, that's exactly right. That's why net neutrality is important.
Yeah. All right, then let's move on and talk about, well, we're already talking about things that are entertainment based, but let's talk even more about them. I threw this in the rundown late and it just broke yesterday, so I don't know if you guys had a chance to even take a look at it, but I'm going to toss it out there anyway and see if you did. And that is that Amazon made a bunch of announcements yesterday for new devices. And one is a set-top box that looks to me like Aereo at home. And it's not the only organization, business, entertainment service provider that is providing something like this, but it is Amazon, and they have a huge audience and a lot of people linked into a lot of devices. So this might be one that gets traction where others do not. It is called the Fire TV Recast. And I bring it up in not just, to discuss that it's there, but to discuss that it does seem to be very Aereo-like. And a lot of people were going, well, but Aereo was shut down by the Supreme Court. It provides the antenna, however, right there in your home. You're not renting a tiny antenna somewhere remotely. So I think it avoids Aereo's legal problems, as do the other devices that operate in the same way. I always think it's interesting when there's a new disruptive entertainment providing set-top box kind of thing, where I'm sure that there are lawyers in rooms looking at this going, well, is there anything we can poke at here? Is there anything we can attack? What do you think, Nate? Is there?
I doubt it. Also, part of the reason that Aereo got crushed so thoroughly is because they were a startup being nailed by the big content companies. Amazon ain't no startup, and they're going to be able to fight anything back. I think the Fire TV Recast is interesting, but maybe the more Aereo-like product that's out these days is YouTube TV. YouTube TV is Google's subscription TV service. So it's almost exactly Aereo-like in the sense that you subscribe to a service and get network TV streamed to you. The only difference between Aereo and YouTube TV is that YouTube TV is paying a license to the networks, and Aereo obviously did not. Fire TV is really just a TV tuner with a DVR. It's almost nothing more than TiVo was at the time. TiVo survived all the attacks. The only difference between Fire TV Recast and TiVo is that TiVo, you had to be next to the TiVo in order to watch, and Fire TV you don't. But otherwise, they're the same technology.
Right. And again, getting back to how very, very ancient I am, I remember Replay TV, which got shut down because it tried to let people skip commercials, and it ultimately was sued into bankruptcy over that functionality. The networks and rights holders, entertainment rights holders, seem to have gotten over, or at least decided they're not going to fight that battle that vehemently anymore. There was also was it the dish hopper that had the commercial skipping feature that there were always some copyright arguments trotted out to, hey, you're messing with the copyrighted programming that we are providing to customers. So that just popped into my head as to this device as well, and possibly as to YouTube TV's service. Do you know if it allows you to skip commercials?
Oh, it certainly does not.
So that is licensed. So that's by design. This has a DVR function, so I am assuming that it would let you do that. I'm also assuming it's not licensed because it's just acting as an antenna. So interesting stuff. Anything to add, Stefan?
I've never DVR'd anything in my life, and I was always that kid who would go to people's houses and like they'd have 1 million channels and 17 remotes, and I would just be very confused. So this is just going further afield in that direction of, there be dragons as far as I'm concerned. I will admit to literally having no idea how to operate the remotes at my house. My wife always handles that. So God bless everyone who has the energy to learn this stuff. I will rely on others to get the content to me in the filtered form and let the explorers on the internet who want to watch 17,000 channels all at once on 15 devices have their cake and eat it too, as far as I'm concerned. Power to you.
Wow. I think after the show, I have to pack up my answering machine and send it your way. Oh, my goodness.
I would love a landline. I would call people from it and, twirl the little cord, and it would be great.
Would you have a rotary dial too?
Yes. Wasn't there a phone, like a $6,000 rotary phone that sold recently? I want that.
I missed that one.
All right, Matt. Any thoughts about our consumption of television programming and the Fire TV recast or anything else?
I think probably the most interesting thing is this means that Amazon thinks that cable television is going to stick around for a while, because otherwise they wouldn't build this. So they must see that there's a market of people who are going to continue to use cable for the next 5-10 years or whatever, and that they're also going to want to be able to watch this everywhere. So I think that's, their analysis of that from a business perspective is really interesting.
Yeah, I think it's really interesting from a business perspective. If you're someone like a Time Warner or a DirecTV and you're trying to offer huge, expensive suites of programming for people, and they could pick up something like this and still get their network channels and subscribe to everything else that they actually want, you're not going to be happy about this. And your business model is going to need to change. So let's look at the Music Modernization Act, something we've talked about on and off on the show, that has been wending its way through Congress. And after much sort of horse trading and alternative acts proposed and negotiating, it actually passed. And it does a few... like a lot of things that get passed by Congress and get negotiated on their way to passage, I think it didn't make everybody happy on any side of the discussion around the act, but that probably means it's a pretty good bill, right? It's not as bad as it could have been. It's not as good as it could have been. One thing it does do is address this problem that we've talked about before on the show about how there were different laws in different states for recorded music before 1972. Now, basically, federal copyright law is going to apply to that music, and there won't be these strange discrepancies and weirdness about pre-1972 sound recordings. There's also a really interesting orphan works sort of provision that allows you to go in, say you want to use a piece of music, it's before 1972, you want to use it for non-commercial purposes. You have to check that it isn't in commercial use. I don't know how you do that. Just make sure it's not being played in a car commercial, maybe. I don't know. And then you have to file something with the Copyright Office, and the rights holder, it then shifts the burden to the rights holder. If you've filed something as to that piece of music, if no one raises their hand and said, yeah, I own it, and no, you can't use it, then you get to use it for non-commercial use, which is a nice provision. Anything else about this that caught your eye, Nate?
So I sit on the civil liberties team, and when this bill passed, I ran down the hall to my colleagues on the IP team, and I said, "What do we think? I need an EFF blog post to describe what we think about this." And they were like, "Well, it's 186 pages, and it's going to be a while until the blog post goes up." Right. My colleague Mitch got the blog post up in absolute record time earlier this week. It is truly a mixed bag. There are things we hate about this bill. There are things we love about this bill, and there are things that we understand are a reasonable compromise in this bill. Mm-hmm. It was a whole heck of a lot worse than the version that the House passed. So I don't know. It could have been worse. Could have been better. And now I think it remains to be seen what the House does to the bill.
Okay, we will stay tuned and see what happens there. Any thoughts, Stefan?
Really a question for Nate. And do you have any insight as to who represents the non-copyright holder interests in these discussions whenever there's lobbying activity or proposed amendments to a bill like this? It seems to me that there's an obvious concentration of power and resources on the major label side. Who's opposing them, and who's pushing for the compromises that have improved the bill along the way?
Well, EFF obviously is one. Our friends at Public Knowledge, which is a DC-based civil society group that focuses on this. Creative Commons obviously is very active, as are organizations like Engine, which is a lobbying and advocacy firm that is funded by and founded to protect the interests of startups. Because startups are doing interesting things with this kind of content. And on their own, an individual startup doesn't have any lobbying power, but when a couple hundred of them get together, as they did with Engine, they're at engine.is, I think, then they actually have some real power. So us, PK, Engine, Creative Commons are the big players here.
Would you be willing to estimate the sort of relative resources on each side? Is this still the David Goliath story, or is it fairly equal once you add up all those people?
No, it's Goliath versus the Ant-Man type.
Well, here at least the Ant-Man, the Ant-Man's pretty strong. Got a couple movies under his belt.
Indeed.
And had a big impact on this legislation that could have been a lot more industry friendly. That's something Mitch Stoltz points out in his article at EFF, that people got vocal about what was wending its way through Congress and got in touch with their representatives, and change happened, so it's a good thing. Matt, any thoughts?
Yeah, I mean, I think that the feeling is it's better than it could have been, but I continue to think that it's just preposterous that if the whole point of copyright law is to give incentives to create, that somehow 80 years later we're going to extend them even further beyond. It's just mind-boggling that this is even a credible argument to extend the copyright on things that were created years and years ago. I think it just historically, when it began, I think it was 24 or 28 years that you got a copyright for. And, there was even grant back provisions against, so publishers after half the time didn't get the right to publish. It went back to the original owner. And that seems like a much, much more sensible position than what we have now.
Absolutely. And one of the notes I would put on this bill is that for certain classes of music, it extends copyright. For instance, for recordings made in 1956, they won't leave copyright until 2067, 110 years later. That is a whole lot longer than the original copyright terms.
There's going to be a whole lot of doo-wop music resurgence in the later part of this century, apparently.
Anybody want to guess what
Elvis'
Elvis' first album?
Oh, what were you going to say about Elvis?
Anybody want to guess what year Elvis's first album was released?
Was it 1956?
Yep.
Yep. That makes sense.
I wonder
All
if
right.
that drove this.
Yeah. Okay, let's move on to look at this is something we flagged for discussion a couple of weeks ago and shelved, and now we have a couple of things that relate to, speaking of how long music stays in copyright, classical music that is soundly and roundly in the public domain that is getting caught by content ID filters, specifically on YouTube, but it's not the only place that uses Content ID, and now the EU wants everyone to use it. So it's just sort of a case study, I guess, in how flawed those filters can be. A couple of instances recently, one involving a professor in Germany who decided to do some experimenting on classical music. And in his particular instance, he was making educational videos. So well, obviously, even if you're using music that's in the public domain, you shouldn't have to make a fair use argument. But yet he would have had that too, assuming any of what he posted was in copyright. He did some tests to see how much his educational videos would be flagged by Content ID, and the answer, unsurprisingly, was a lot. And he was including works by, let's see, I'm not sure. Oh, here we go. Bartok, Schubert, Puccini, and Wagner. And he did have some success in pushing back and getting his videos reinstated. He was a little upset they were not converted to a free Creative Commons license, which is what he wanted. But still, he had to go through this huge process and agony to be able to get his videos up. And then we have the instance of another musician in this case who recorded himself playing Bach. And here it wasn't on YouTube, it was on Facebook. And Sony Music, of all people, asserted rights in the 40 seconds of performance that he posted. And his name, James Rhodes, then had to go back and forth with Sony Music. There is a great piece at EFF about this, pointing out that not only does a bot, a Content ID sort of bot, seem to have flagged the music for, hey, you should take this down to begin with, but then it seems to have been involved in the appeals process as well. Because Rhodes pushed back and pointed out that the music was actually older than the entire U.S. copyright system, and yet Sony Music stuck to its guns, claiming to be the rights holder here. Nate, other than these things are not perfect, what can we do to encourage folks like Sony and others to take the appeals process seriously?
That is a great question. Mm-hmm. There was another piece that we published at EFF a while back. This is in our Takedown Hall of Shame. It was earlier this year. An artist who published a video on YouTube that was 10 hours of white noise, just static, got 5 copyright takedowns for 10 hours of static video, right? Obviously ridiculous. I think what we have to do is we have to realize that robots are not the solution here. Automated content moderation just has absolutely horrible accuracy at this point. And it's it's not just that it's not a silver bullet, it's actually bad at doing its job. What is there that we can do to get rid of it? Not that much. It looks like it's here to stay. The thing that we need to do is make sure that it doesn't get imported into different fields. Copyright is actually one of the easier fields here for bots to do. Shazam, the cell phone app that listens to a song and compares it to a list of songs that it has up there in the cloud somewhere and tells you what's playing, can only do that because it has recordings and it's doing an actual match. That's what Content ID is supposed to be doing. In the Facebook Sony Music example, it was apparently doing something else because it was not a recording that Sony had made. It was a brand new recording that Sony still matched. We're seeing folks both on Capitol Hill and in Europe demanding that systems like Content ID be repurposed for discovering and taking down terrorist or extremist content. That is even worse of an idea. Extremist content is often brand new. And the heuristics involved are, as I think we've seen from the Sony Music Bach takedown, the heuristics are terrible. The content industry has a ton of money, and they're still bad at it. They still issue 5 takedowns for static. If we start doing automated takedowns for extremist speech, we're going to get a whole bunch of legitimate speech being erroneously taken down. And at the same time, instill a false sense of security that actual extremist speech is being taken down when we know that there are false negatives as well as false positives. So Content ID might be here to stay in the copyright realm, but we have to resist its expansion outside copyright as hard as we absolutely can.
It seems like the courts, well, first of all, the DMCA itself has a provision that if you wrongfully oppose someone's claim that they have the rights to this material in the notice and takedown process, you're supposed to be on the hook for their expenses in prolonging the discussion about whether the piece should be up or not. And then secondly, we have the Dancing Baby case from the Ninth Circuit that had some discussion of a burden on the rights holders to reasonably consider fair use in their analysis before deciding something should be pulled down. Stefan, it just doesn't seem like, certainly in Sony's case here, moderating this process with bots throughout the process, it doesn't seem like they're very intimidated by those potential downsides.
It doesn't seem that way at all. And I guess I don't know enough about the mechanics here. Are there any penalties if they do any false positives here? And is there any downside, or can they just be over-inclusive without real fear of repercussion? I mean, what's the kind of framework here? It's something I just don't know enough about.
So after the Ninth Circuit's decision in Lenz, which is the Dancing Baby case that we represented Stephanie Lenz on, the standard is if they had actual knowledge of a potential fair use claim, then there are penalties of them against them. If they just got it wrong, then there's no penalties. And if the bot is out there operating on its own, there are no penalties. I think there's an important distinction to make here, which is that the Ninth Circuit's ruling only extends to DMCA takedown requests. Content ID is not a DMCA takedown request system. It is a less than DMCA takedown system.
But doesn't it trigger the system? Isn't that how they know it doesn't?
It doesn't actually.
Okay.
Content ID triggers Content ID, which is YouTube treats as separate from DMCA. And Content ID strikes don't have the same. It doesn't have the same counter notice provision, and it doesn't have the same 512F protections.
It's a really good distinction to bear in mind.
Yeah, Content ID is only available to the big guys. Independent labels don't have access to Content ID. Independent artists don't have access to Content ID. You have to be a trusted partner, which means with the big, however many music or movie companies, in order to get into Content ID. Those companies are still free to do DMCA, which is a stronger, but both stronger and weaker in some senses. But Content ID is an extra legal system.
Right. So the difference there is Content ID sends you a notice, and it takes things down though too, right?
It does take things down, but it's not a DMCA takedown in the sense that you can't do a DMCA counter notice and automatically get your stuff back up. And it's not under penalty of perjury like a DMCA takedown is.
Yeah.
And has anybody tested the actual knowledge standard in the robot context? I mean, if this is a program that's identifying these things, how would that play out? I mean, whose knowledge is relevant if it's a robot that's tagging these things?
We'll find out eventually, but we don't know yet.
Yeah. Matt, any thoughts?
Yeah, I think that it seems like I think that's what Stefan is alluding to. It seems like an odd carve out that if I put in a system that keeps knowledge out of it, I wouldn't be liable for damages for, by not knowing anything. That seems like, especially when you're enforcing your supposed rights against someone else, it strikes you as that's an excellent place for punitive damages. On the other side, with the takedown, with the instance of old, music that's outside of a copyright realm, I think that is actually from a design perspective, that's a very difficult place to carve out. Where it wouldn't have a takedown for, because when you think about the system as a whole, 99.9% of all things that are going in there have a copyright on them, and even your music. So if I'm recording a terrible version of Bach, my recording itself does have copyright for it. So you'd almost have to have, as a system, to not flag these things. You don't have to have a recording of the music for music that is outside of the copyright that would automatically not flag recordings of that. And so that is, I think that's why these sort of stories show up in the news so much, is because, it seems outrageous that YouTube would flag that. But from like a design perspective, it really makes more sense that those are the ones that are showing up, and not great and not good. And they should improve upon that. But I'm much more concerned about the sort of automated enforcement that Sony's doing, than recordings of Bach or somebody getting picked up by the Content ID, because I think that does make more sense from a design. Obviously, YouTube should work on fixing that and everything like that, but it does make more sense.
All right. Let's put our first MCLE passphrase into the show. Let's make it 10 minutes of static. We put these phrases in case you are watching or listening to the show for continuing legal or other professional credit in your field. We have some information for you. Victor, remind me of our short URL.
twit.to/MCLE, I believe.
twit.to/MCLE. That's a page over at the Twit Wiki. If you have any trouble finding that, that's at wiki.twit.tv, where we have a chart of some states in the United States where you may be able to apply to receive continuing legal education credit. We'll support you with that. And one of the ways that we do that is we put these phrases into the show in case your oversight body needs to know that you actually watched or listened. So we'll put another one in before we go ahead and wrap up the show today. And right now, we're going to move on to discuss some issues pertaining to privacy. Nate, you do work at EFF related to anonymity, if I'm not mistaken. Is that right?
Anonymity and cybersecurity are my two big areas.
Right. So I kind of wanted to get into the anonymity piece here as we consider privacy in general, because we've got a Senate Commerce Committee meeting coming up later this month on September 26th. That's next Wednesday, if I'm not mistaken. where they're going to be discussing consumer privacy online. EFF and some of your cohorts have not been invited to attend that meeting. Why is that, Nate?
Well, I think it's a whitewash. Whenever you have a hearing on consumer privacy and you invite Google and Facebook and no consumer privacy advocates, I think there's only one thing going on, which is the members of Congress who are here aren't serious about wanting an actual privacy bill. So there's the old saying that something must be done. This is something, therefore we must do it. That saying has more truth on Capitol Hill than probably anywhere else in the country. After Cambridge Analytica, members of Congress were swamped by their constituents demanding action on privacy. Do something to prevent the next Cambridge Analytica. So all sorts of members of Commerce are putting together bills right now. Many of them are based on, for instance, the U.S. Chamber of Commerce's principles that came out earlier this month. And the bills are not uniformly bad, but a lot of them are really bad, really just terrible privacy bills. And the companies are lining up behind them, lining up behind bills specifically to preempt state action here. California passed a pretty comprehensive privacy bill earlier this year, and Facebook and Google want nothing more in this world for the feds to preempt that California bill before it goes into effect. And the way to do that, hold hearings without actual consumer advocates. And that's exactly what they're doing next week.
So the way you see this playing out then is the Senate Commerce Committee will have this hearing, and do we have an actual bill on the table, or are they still coming up with something?
They're still in the drafting phases. If I have seen language of a number of these bills, I couldn't tell you.
Mm-hmm. Got it. So the reason I brought up anonymity, this seems to be, as you say, a parallel effort that maybe would be designed to preempt laws like the one recently in effect in California, the consumer, it's CCPA. What does that stand for? California Consumer Privacy
Act, I think.
Yeah, I think so. So if there were a more watered down federal version, that would apply. But I brought up anonymity. They're, dealing in this bill that they seem to be working on with treatment of consumer data. But I'm wondering if you think it will get into, also Congress has been obviously very concerned over the last several months, not just with how data is treated, but how platforms are operating in general. And I'm wondering if anonymity is particularly under attack right now.
I think anonymity is under attack from the company's point of view, but probably not on Capitol Hill. The law is pretty well settled here, that we have a right to anonymous speech under the First Amendment, including anonymous speech online. Going all the way back to 1997 and ACLU versus Reno, the First Amendment applies online, and that includes anonymous speech. Companies are still free to prohibit anonymity on their platforms. That is the company's right. But allowing the government to do it is something that the First Amendment doesn't tolerate. Right now, Congress has the Honest Ads Act up on, I think it's in committee right now. The Honest Ads Act would require all election-related advertising to have funding information, including online. Right now, not all ads require attribution, and there are First Amendment problems even with that. So I think we're going to have to wait to see what actually gets what actually gets proposed and goes up for a vote in committee. But right now, I don't see a tax on anonymity as particularly dangerous. Congress could prove me wrong. I hope that they don't.
Right. Or as you say, they don't need, if a platform decides the way they're going to deal with the criticism they've been getting is to require there to be a one-to-one correlation with a real world identity and an online identity, then that's up to them to operate that way.
That's right.
I bring it up too because there's this interesting little piece we have in our discussion points for today. You can look at everything that we've looked at to get ready for the show today. If you go to tagpacker.com/user/thisweekinlaw, we're on episode 435 this week. There's a study that someone decided to do where they polled over 2,000 online users about their sense of well-being after they had used the platforms. Here's how they described the study. In order to better understand society's relationship with the internet and to see how well we as a company were delivering on our mission to lift the world's spirits, my team and I partnered with the research specialists at YPulse to survey 2,100 internet users about which platforms they use and how they feel after using them. This was by Alan Schaff, so I'm not sure who he's involved with that are lifting everyone up. But the interesting outcome of their study is not that surprising in hindsight, I guess, is that people have a better sense of well-being when they're using the internet in sort of an anonymous way. And by that, I mean their focus is on consumption rather than participation. They are being entertained. Were you entertained? And that when they're using Netflix or YouTube in that kind of capacity, they feel pretty good, and they're not, feeling all beat up the way they might if they were getting into the trenches on a political debate, say on Twitter or elsewhere. So I just wondered what you thought about this, Nate.
In my own lived experience, I have found some social media to really instill a sense of well-being and some social media to really not. I go on Instagram to look at pictures of puppies and of food. I deleted my Twitter account because I used to go on Twitter to get in fights with strangers on the internet. But I may be unique about that. Deleting my Twitter account, by the way, has done wonders for my blood pressure, my mental health, and my marriage. So I recommend it to everybody.
Right. Well, I mean, Apple seems to agree with you. They have, on the one hand, the watch wants you to close your rings by getting all your exercise and being active. And now iOS 12 wants you to monitor your screen time and make sure that you're not going on the internet to get into fights too often, I guess.
I don't yet have the guts to turn screen time on in my phone, but maybe I will after this show.
Right. I turned it on. It's very unobtrusive. I think you can make it obtrusive if you want it to be. But just to go in and see what you're actually clocking in at is fairly interesting. All right. So we mentioned the California Consumer Privacy Act. We have another piece in the rundown that talks about its private right of action provision and the fact that we should probably be looking to see a lot of lawsuits under the new act in short order here. I don't know that the floodgates have opened yet, but I think this piece that's by a couple of lawyers from Manat Phelps is probably right, that there is going to be a lot of private enforcement under this, meaning a lot of lawsuits. There's probably a lot of exposure as people try and get themselves into compliance. Do you agree that we're looking at a pretty big uptake here in California as the plaintiffs' bar decides that it's time to have at these companies for their violations of the new act?
Well, I don't know. I I'm waiting to see what happens with the new act. There's no chance in hell that it's going to go into effect as written. There are simply too many typos and other problems with the act. It will be revised before it goes into effect. For us, the next fight is going to be over those amendments to the bill. The bill isn't scheduled to go into effect until January 1st, 2020. So next year, the legislative session, which officially opens soon, but for reals opens in January, it's going to be all hands on deck to make sure that the bill stays strong and doesn't get watered down before it goes into effect. So I think before speculating about what the plaintiff's bar is going to do, we have to keep our eyes trained on Sacramento.
Got it. Matt, any thoughts about any of these privacy issues?
Yeah, just from your perspective, Nate, it seems like if you're writing a privacy bill, there would need to be a private right of action. Is there much argument for not having one?
Well, obviously the companies don't want a private right of action. The companies have gone so far that they, as to say in the federal context, the companies are saying they don't even want state AGs to have a right of action under the federal privacy right. I think those arguments are purely cynical and really say nothing more than the companies don't want a real privacy bill to go into effect. But I completely agree that without a private right of action, it's useless to even talk about this.
So it would only be the U.S. attorney? They would.
That's what the companies want.
Yeah.
Well, no, the companies want. It's worse than that. It's not that they want the U.S. attorney. The companies want the FTC to be the exclusive enforcement body. The FTC obviously does not have very much bandwidth. They have 15 privacy lawyers total in Washington, D.C. And that's, the FTC's teeth are short and dull.
Well, other than the plaintiff's bar, it doesn't seem like too many governmental actors are real excited about being the enforcement body. Xavier Becerra in California, he's the attorney general here, has said his offices face serious operational challenges in getting prepared to enforce the CCPA. So, but that's what we're paying them for. They got to ramp up. What were you going to say, Matt?
And how does this relate to arbitration? Is this exempted from arbitration, or is this can I make you sign a contract that you have to arbitrate this?
I have no idea. I'm sure somebody knows.
What do you think, Stefan?
Is there a risk that a private right of action in this context could lead to some bad precedent early on that could hobble the act and sort of undermine its goals? In other words, do those advocating for the act perceive some advantage in having a more streamlined enforcement process out the gate to establish interpretations and norms around it that are going to be administrable going forward rather than letting the plaintiff's bar loose on it? It just seems like a risky move if what you're trying to get is an optimal policy outcome.
So that's why EFF has such a strong amicus practice, is because we know the plaintiff's bar is bound to muck it up. So we try and get in there and argue what we think the law should be rather than what the plaintiff's bar thinks the law should be. So even when we file briefs in support of the plaintiffs, which I'm sure we will be doing when this bill goes into effect, we will help clean up the mess that they create as they do it.
All right, let's move on. We haven't talked about kid-specific stories for a while, so let's do it right about now. That bumper never fails to crack me up. Okay, so I heard from Common Sense Media a couple of weeks ago. They did a poll that they released the results from that were basically echoed the sentiments you said a moment ago, Nate. They were asking kids about their social media usage, so they got some numbers about that. but also about its impact on them, whether they felt better or worse, like the other study we were discussing, as the result of their online activities. Most of them said that they feel like it's an improvement to their life. It makes them feel more confident, less lonely, and less depressed. When asked if they think it contributes to their relative feeling of depression, almost 60% of them said they didn't think it had any impact on that at all. Now, again, can teens really be the best judge of gauging that? Maybe they're skewing their answers so nobody's going to take their phones away. But there's some pretty interesting data here that maybe things are not as bad with teens and devices as the hand-wringing public might suspect. Stefan, did you take a look at this, and do you have any thoughts?
I did. I find it a little surprising that teens are reporting such positive experiences with social media, because it runs so counter to the narrative you hear in most other places. So I would hate to speculate about the psyche of contemporary teenagers as a group, because it's a diverse group of people that I have very little contact with. But I'm a little suspicious at these responses. It doesn't seem to square with everything else I've read about it.
Mm-hmm. And I mean, the other thing that really didn't come into play here, that's much more sort of in your wheelhouse, Nate, is their perception of their privacy and the use of their data. There was a little bullet point here that talked about, 3/4 of them said they believe that tech companies manipulate people into spending more time on their devices. And more than half said using social media often distracts them from homework. So while they have this positive impression, maybe they have some sense of their role and the role of their data in the ecosystem. But do you feel like they really appreciate all of the ramifications of that?
I think kids have a much better sense of online privacy than we do. I think kids are masters at selecting being selective in which channels they use, whether they tweet or Facebook or Snapchat or Insta or Finsta or whatever. Kids are actually a lot better than we give them credit for on this. I think one thing to note here is that they're absolutely right that the social media companies are doing things to make them addicted to their phone. I'll give you a concrete example. Something that Twitter does that Facebook has decided not to do. When you open the Twitter app, there's something like a 3/4 second pause between the time that the screen loads and the time that the little notification pops up that says you have 6 unread notifications or whatever. Facebook, that's immediate. Facebook, the number of unread notifications pops up as soon as it's loaded. There's no intentional delay. The intentional delay that Twitter put in there is in order to peak that little, I forget which hormone, but there's whichever hormone it is that that slot machines trigger in our brain to make us anticipate that jackpot. Twitter
Dopamine.
They did research actually to figure out how long that delay should be, and they put in that delay so that we have that a little whatever. It's not adrenaline. It's some other
dopamine.
Dopamine. We have that little dopamine rush as we sit there waiting. Oh, is it going to say 15? Am I popular? Oh, click. So yeah, the companies really are doing that. They hire neuroscience PhDs to figure out how to make their stuff more addictive. They don't call it more addictive; they call it engaging internally. But make no mistake, they really are doing that.
Yeah, that's fascinating. Stefan, any final thoughts on this?
I'm glad I'm not a teenager.
I think we're all glad we're not teenagers. All right. Maybe we're also glad we're not social media companies operating in the UK, because speaking of having to ramp up, how you present your services to the world. In the UK, social media firms now face new fines if they send children notifications at night. They're not supposed to disturb them with alerts at night or during the school day. So the logistics of that seem problematic to iron out, to say the least. I can certainly, see what's motivating that. But if you're letting your kid go to bed with their phone, I guess maybe you should know that they might get a notification, but not in the UK apparently, because they're going to be fined for that kind of activity. Nate, do you see that as something that might become a broader standard?
No, I don't. I think the chances of this becoming law in the United States are just about nil. Part of the problem is who's a kid, and how do the social media companies know who a child is or who a child isn't? Google knows a little bit who kids are because children who use Google Apps for education in the classroom usually stay signed into their Google account. The same is not true with Facebook. I mean, how many kids do you know on Facebook who are truthful about their age? My guess is the number is 0 or close to it. So this is an interesting idea, but I don't see how it's administrable.
Yeah, something caught my eye. I thought it would be interesting to present here on this episode of This Week in Law. All right, let's move on and talk about the opposite of kids. Let's hope it's the opposite of kids. Folks involved in the criminal justice system. Nate, you were quoted in a piece discussing Michael Cohen and Paul Manafort and how some of what we know about them became widely known. Tell us about their use of encrypted communications.
So Trump's erstwhile campaign manager, Paul Manafort, used encrypted messaging services, as pretty much most of official Washington does at this point. This didn't start under Trump, but it accelerated like gangbusters during the Trump administration. Folks know that their communications via text message, via email, via Facebook Messenger are not secure, and they know that the government could well be listening in. So people have turned more to things like WhatsApp and Signal and iMessage and Telegram, which are much harder for the government to listen into. Operational security, OPSEC as we call it, is really hard, however. WhatsApp, for instance, constantly prompts you to turn on online backups to make sure that you don't lose your messages. But what online backups means is that your end-to-end encrypted messages that no one, not WhatsApp, not Facebook, not Apple, not Google, could read the contents of, all of a sudden you're backing up those messages to iCloud, and with a simple search warrant, the government can get the full content of all of them. Signal has a slightly different backup solution that doesn't end up putting the content of messages in clear text in a way that Apple or Google could access. Telegram is just really confused and does all sorts of different things that could possibly leak content. But I think what Paul Manafort got caught in here is the most simple of OPSEC errors, is he was messaging the wrong person or people. The government got Paul Manafort's secret encrypted text messages in two separate ways. The first way was that the people that Manafort was texting went to the cops with the text messages and say, look what Manafort is texting to us. There's technology is not going to be able to solve that problem. The second is the cops, after they already saw the text messages from the people that Manafort was texting with, went to Apple and pulled the backups to show that they were also on Manafort's device. That's, as I said in the article that you just flashed a picture of, everybody messes up OPSEC. Here at EFF, there are some people who use PGP for encrypted email. I don't have PGP on my phone, so when someone sends me a PGP encrypted email when I'm away from my desk, honestly, all I have to do is say, on phone, no keys, resend, ? And it comes through in clear text, right? OPSEC is hard. And I certainly don't blame Paul Manafort or Rick Gates for messing it up as thoroughly as they did.
Is this something we're just going to see more and more of as people feel like they are locking down their communications, but they just don't recognize that they're compromising their own security?
I don't know if we're going to see more and more of it, but we're certainly not going to see less of it.
All righty. Stefan, any thoughts?
Boy, I hope I never have to find myself in the position where I'm messaging someone over, encrypted text messages and hoping the government's not reading them, because I will certainly screw it up if it's one of those things where I appreciated this article because it reinforced my own bias here, which is to say that most of the time that the phrase encrypted communication is used, it's very misleading and it doesn't actually mean what people assume it means. And I was glad to read that because I've never really been able to wrap my head around why does it feel like I'm doing this wrong? And the reason is because everybody does it wrong. So I liked reading that.
Yep. Matt?
Yeah, I think I'm with Stefan here that realizing my assumption in using WhatsApp would have been that it would not have backed it up to the cloud. So that seems like a major, either short-sighted on their fault or short-sighted on, me as a consumer's fault, not knowing that they're backing that up. That's just interesting.
Right. Nate, do you have a favorite encrypted communications tool these days?
I have two favorites. My two favorites are WhatsApp and Signal. There's a couple of reasons why you'd want to use one versus the other. If you're in the United States, I think Signal is probably the best thing for you to use. If you're in the only reason why you wouldn't want to use Signal is if you're in a jurisdiction where the government believes that the use of encrypted messaging services per se is evidence of criminal activity. Much of the Middle East is that way. Russia is that way. China is absolutely that way. So I wouldn't use Signal in those jurisdictions. I'd use WhatsApp in those jurisdictions. But a difference between in the United States, they're both good options. WhatsApp, you have to be a little bit more careful. You have to make sure backups are off. You have to make sure that key change notifications are on. And you have to make sure that the people you're talking to have backups off and key change notifications on. Signal is secure right out of the box, though.
Right. And that's why it's more dangerous in the jurisdictions you mentioned.
That's right. Using Signal in Saudi Arabia is enough to get a visit from the religious police, just sort of on its own without any other activity.
Wow. Okay. Let's stick with encryption and instead consider it from the policy standpoint. Talk about what Washington may do about it. Or maybe not just Washington. Tell us what Five Eyes is, Nate.
Five Eyes. Five Eyes are the five Anglo countries that stick together. The UK, Australia, Canada, US, and New Zealand are the Five Eyes. The intelligence agencies, in the US we call them the intelligence community, of those five countries collaborate very, very, very closely and have for a long time, essentially since World War II. They share information not just on individual cases, but they actually share entire systems. The sorts of systems that Edward Snowden told us about in 2013, PRISM, X-Keyscore, et cetera, those systems are shared between the five countries. And all of the data in them are shared. Maybe not all of the data, but most of the data in those systems are shared directly by the Five Eyes. They also have some policy cooperation. The justice ministers and foreign ministers and intelligence ministers. Here, of course, we would call them, cabinet secretaries or directors of national intelligence, issued joint policy statements together. And that's what happened in Australia just a couple of weeks ago. The Five Eyes issued a statement on encryption. To us, it read like it was really led by Australia and the UK, and not so much the US, Canada, and New Zealand. We might be wrong about that, but that's the way it read to us. And the Five Eyes statement on encryption was really just more of the same. Exactly what we've been hearing from the intelligence community since the mid-90s, really. This quote, going dark, unquote, narrative that they're so fond of. Essentially what they're saying is, we need the tech companies to give us plain text, everything, all the time, whenever we want it with no delay. And that is storage, device unlocking, as well as communication services. So this is Apple versus FBI plus an attack on WhatsApp and Signal and iMessage. Everything all rolled into one. What the Five Eyes communique, their joint communique, said essentially is the tech companies just need to find us a way of doing it. They don't have a choice. If they don't, we're going to legislate it. Those legislative efforts are already well underway in Australia, and the law was actually the law was enacted in the UK back in 2016 that gives the UK government the power to ban encryption. The UK government hasn't used that power yet. Australia hasn't passed its bill yet. But the Five Eyes communique gives a roadmap of what a roadmap of our greatest fears, essentially, in that if it seems like the UK and Australia are moving very quickly towards banning encryption, full stop. If that happens, it's going to be a really interesting showdown between Apple and Facebook and those two countries. And I think the future of our digital security rests in the balance. That sounds like a crazy thing to say, but I don't believe it's an exaggeration.
Do you feel like the United States, Canada, and New Zealand will follow suit if Australia and the UK do what you think they're going to do?
They don't need to, which is the crazy thing. If the UK mandates that Apple change its the way it does device encryption or device unlocking, or if they mandate that WhatsApp or iMessage change the way they do encryption, the companies are going to have to build those systems for the UK. And once those systems are in place, there's nothing preventing the FBI from accessing them. It's not like UK citizens are going to get an insecure phone, and American citizens are going to get a secure version. That's not plausible to me.
Yeah, it's not. It's not efficient either, right? I mean, they can't make a different product.
No. So once the UK or Australia gets it, that's it for us too.
Wow. So what do you think the companies are going to do in response?
Well, so Australia had a public comment period open last week for everybody and their mother to give comments on this proposed bill. 14,000 comments were submitted. EFF submitted our own, of course. And the companies all submitted theirs. And the companies were essentially unanimous, saying this is terrible. This will destroy the security, not just of Australians, but of internet users around the world. And in response to those criticisms, the new Australian government fast-tracked the legislation. So they essentially said, we don't care what the tech world thinks, we're going to do it anyway. They haven't passed it yet. I don't remember exactly when the vote is scheduled for, but I think it's this month or next. So we will see. The UK government, as I mentioned, already passed a similar bill. It's slightly smaller in scope. But the UK's bill gives the Home Secretary the ability to issue binding orders to the companies to turn off encryption or other security features. We know they haven't done it yet, but we know that they're working on figuring out what their first orders under that bill, which is called the Investigatory Powers Act, are going to look like. So it's a waiting game. We have another comment opportunity open in Australia, and we're looking for ways to open a comment opportunity in the UK. We'll keep readers informed on our blog, EFF.org, for when and if that happens.
Do you think there's any version of reality where the companies offering encrypted communication services just say, okay, Australia and UK, we're not going to do business there anymore?
You know, that's a fantasy of mine, but I have a lot of fantasies. I think that the chances of Facebook doing that, Facebook, of course, controlling WhatsApp, seem pretty slim. The chances of Apple just saying, okay, well, then no iPhones for you, UK, or maybe just no iMessage for you, UK. Who knows? Tim Cook has more money sitting there in the bank than any company ever has in the history of the world. Apple has more cash on hand than any company ever. Could he weather a Apple boycott of the United Kingdom? Probably. Is he going to? I don't know.
Right. It seems like there's not been any sort of anybody giving ground on this notion that where the governments are saying law enforcement needs access to do these investigations, and the company's saying if we compromise the security for law enforcement, we compromise for all. Do you have any intel for us on any sort of middle ground there?
No.
No. I didn't think so, but I had to check.
There's an EFF blog post whose title is, I believe, "There is no middle ground on encryption." I suggest that the audience take a look at that one.
Yeah. Matt, any questions or thoughts?
So I'm just surprised that this is an all or nothing thing as well. Is there no, we think of more stringent regimes such as China or Russia? Do they not have a backdoor access at all right now then?
They do not, at least not to the services that I'm talking about. China has backdoor access to all sorts of stuff, but not Apple or WhatsApp.
And that seems like the bigger threat there. I could see theoretically at least, Apple withstanding Australia, which has 25 million people. But any indication of what China is staying on this?
So China has done a couple of things on this. The two major ones is China has banned encryption apps from the Chinese App Store. Apple runs a different app store in every country, so you can't download Signal or WhatsApp in China. You can't download VPNs in China either. And then China has required that Apple support its own backdoored version of Wi-Fi on iPhones sold in China. They so far haven't really cared about device-level encryption. It's our belief that intelligence agencies and law enforcement can probably unlock any device on the market with things like Gray Key or Celebrate. The Chinese appear to have their own, otherwise they'd be making a stink about it. So right now, no, we haven't really seen pushes from Russia and China, at least not on the big American companies.
Stefan, anything you want to add?
Quick question for Nate. The article that you're quoted in here, you say something along the lines of that, this legislation reeks of Australia. And I thought that was a striking sentence because it sort of implies that this is some pattern of behavior that Australia has demonstrated. And in the same article, you note that Australia is not getting a lot of tech sector investment. And so maybe that as an alternative to building up tech companies are going after them. Do you have any insight as to why Australia is doing this? What's in it for them? What interests are behind this? It sort of seems like they're taking on this massive fight, implicating the U.S., Canada, the UK, and New Zealand in that fight, and both industry and consumer groups are against them. So who's on the other side here, and why are they doing this?
I don't know how well versed you are sort of Australian social politics, but right now Australia feels itself to be in a national security crisis, and China is the boogeyman here. China and then just immigration in general are the boogeyman. Australians feel very, very, very much under attack. The way that we felt in the immediate aftermath of September 11th, that's kind of the way the Australian public feels right now. I think it's completely unfounded. I think Australia's security situation is just fine. But that is not how domestic politics in Australia play. We saw the former Prime Minister Turnbull say that the laws of mathematics be damned. In Australia, the laws of Australia rule. And then Turnbull lost a political battle within his own party and was ousted from the right. So Turnbull, who was, extremely tech antagonistic, got ousted by someone who is even more so. So that's what's going on in Australia. I think it's almost purely domestic politics and has nothing to do with actual cybersecurity needs.
I just assumed that it was dripping with Vegemite and Foster's.
My Australian colleagues would correct you. They will point out that Foster's isn't actually Australian beer, but that's sort of neither here nor there. It's made in Australia, but it's not sold there. It's only sold here.
Isn't that funny? I never knew. All right, let's move on. We touched on net neutrality earlier, and we've also touched on federal laws preempting laws enacted right here in the lovely state of California. And those two things come together on net neutrality. Ajit Pai actually came out, I think it was this week, and has stated openly now that he thinks that California's net neutrality bill that just passed California's legislature and will soon be signed by Governor Brown is preempted by federal law. So it's no surprise that he feels that way, but he's come out publicly and said it, and the lawsuits will follow. Nate, any thoughts?
Yeah, so legally speaking, that's an absolutely ridiculous claim that the California law is somehow preempted. And why is that so? What Ajit Pai's FCC did is say that they don't have jurisdiction to issue these rules. If the FCC doesn't have jurisdiction, then there's no way it can preempt the states. So that's just a ridiculous argument.
Right. Could they make the argument that maybe they don't have the jurisdiction, but California doesn't have the jurisdiction either, and that what really needs to happen is Congress has to do something? Yeah, they could make that argument.
Congress would have to preempt California's regulation here.
Right.
Of course, the chances of that happening are nil, just because our Congress is very bad at doing anything and very good at doing nothing. So,
well, wasn't the state of affairs not, though, that the FCC said that they didn't have power, but that Congress specifically took it from them in a bill right after Trump's inauguration, saying that they couldn't enact a similar law as to what they had in terms of net neutrality? Not that entirely changes the form of analysis in a a dormant commerce clause type thing.
The CRA didn't pass, actually. It passed one of the houses, but not the other.
Oh, okay.
All right, Stefan, any net neutrality musings for us? Or federalism musings for us?
Yeah, I'm just excited to watch the sort of fight play out, because it's pretty in the weeds in terms of the legal principles that are being implicated here, but it's also gained so much traction in the public that I can't think of another example of something that is simultaneously so technical and legal and popularly discussed. And so it's kind of if you step back from it and think about how many people are impacted and how deep in the weeds the general public has gotten on this stuff, it's pretty interesting and shows a level of sophistication in the discourse that is just sort of impressive. So I'm going to hang back and watch rather than step into this one.
Right. I mean, and it's thanks to groups like EFF that the general public even knows what net neutrality is. So thank you, Nate, for helping people be aware and
I'll pass your thanks to my colleagues down the hall, but yes.
Yes, thank you very much. So yeah, it will be really interesting to see what happens here. I think that procedurally, I guess what we would see is some sort of challenge by a telecommunications company when the law is enforced against it, right? I mean, isn't that logically how this will play out? And they'll say no, federal preemption applies?
I think it'll actually happen before that. I think there will be a pre-enforcement challenge.
Okay. But do you think that there will be anything that stops it from getting signed into law later this month?
The whims of Governor Brown are unplumbable.
I suppose that they are. What else caught my eye here? Oh, that the FCC commissioner is now calling California a nanny state. Seemed notable. His exact quote was, the nanny state California legislators. So,
well,
thanks
and we
for
have
that.
Governor Moonbeam, so there we go.
That's right. Okay, well, we are closing in on the last few moments of the show. I guess we shouldn't get to our concluding material, though. This is almost a tip of the week, but we'll go ahead and discuss it because it is a piece of proposed legislation here as we discuss legislation, regulation, and policy that Matt brought to my attention this week. That will make lots and lots of people happy, except for all the people who publish and make money off of the law, whether it's statutes or judicial decisions. Federal law is compiled in a 4-pay database called PACER, and there is a new bill before Congress that is called the Electronic Court Records Reform Act, that would require documents from PACER to be made free. Matt, did you look into this at all? Obviously, I think the motivations are fairly easy to discern, but what are your thoughts?
Yeah, it's just another one of those things where it's 2018 and we clearly have the digital systems that could make public documents which are filed in a public court free and legal, there's an entrenched interest in keeping them not free and having locked in paywalls for accessing public documents, and it just seems like this is something that should pass, and we should as a public pay to make public documents freely available.
Stefan, you agree?
In principle, I do agree. I think I'm a little bit suspicious about here, and I didn't look too much into the political motivations here. But my understanding is the court system is quite underfunded, and this is a revenue source for the judiciary. And if you're cutting off a revenue source, it sounds like they use some of this money to kind of fill in holes that come from budgetary constraints. I'm a little suspicious that the motivations here are entirely pure, given where the legislation's coming from. But yeah, in principle, sure, we should.
You feel like there's a hidden agenda to defund the court system?
I wouldn't put it as a hidden agenda. That makes me sound like a tinfoil hat wearing type. It's more about it's anytime someone talks about public access. In principle, it's great, but if the effect is you're slashing, taking some money out of an institution that's already underfunded, it's worth pausing and querying what the motivations are here, and whether they're entirely pure. And so, again, this is like a rebuttable presumption coming from me, but what I would say is that there's some value in having revenue streams. I can't imagine there are many circumstances where the 30-page brief that costs $3 to download, this is a make or break for somebody to download it. In most cases, it's sort of a captured audience. They're law firms, but I could be wrong. I'm speculating here, but there's just something about it that smells a little funny to me, and I would love to see more in-depth analysis of what's motivating this.
I think that part of it is the way that negotiations happen, and so the law firms will go and negotiate with, especially on state levels, will go negotiate with courthouses over theirs, and a lot of it's what they'll do is they'll give them access to their public resources, and so if you're Westlaw, you'll get access to their Westlaw for free in exchange for using that. And it just from a negotiation perspective, the courthouse is not looking at that much revenue, but as an aggregate, it is a substantial amount of revenue, and also it means that your publication of some of those opinions are I believe that there's at least claims that they're under copyright, and so I think that's where the problem comes in. When you put West's head notes in there or anything like that, their copyright claims come up.
Right. See also Carl Malamud. If Nate, any thoughts about Pacer going free?
So it'd be great if Pacer went free. I think that would be an unqualified good thing. I agree with Stefan's skepticism of where this act is coming from. The sponsor is Representative Collins from Georgia, who is a far-right Republican and generally not a fan of the courts. Also, I would note that this bill is not an appropriations bill. And what that means is that it doesn't have money attached to it. So eliminating Pacer, which is one of the administrative office of the court's main revenue streams, would leave the federal court systems completely hamstrung for money. I don't think this bill has a snowball's chance in hell of going anywhere.
Okay, well, it'll be interesting to. Yeah.
If it were an appropriations bill and was self-funded, we would be out there lobbying hard to get it passed.
Right. So you could see this being recast as something that addressed the defunding the court system issue and allowed free access to the documents.
I don't see it happening out of Representative Collins' office, but yes.
Yeah. Okay. All right.
I feel so validated.
Yeah, exactly. Let us move on to our concluding material for the show. Let's do our resources first, since they both come from Nate. Nate has two great things at EFF that you should check out if you have not checked them out already. Tell us about Who Has Your Back, Nate.
Who Has Your Back is one of EFF's longest running projects. This, I think, was the 8th edition or something like that. And we did something different this year. In prior years with Who Has Your Back, we rated the big social media and other user-generated content companies on how they treated user data in when the government came knocking. Essentially, when the government requested user data, what sorts of rights and procedures do the companies give? This year, we went in a different direction. We went with the censorship edition. So we looked at companies that have lots of user-generated content, video, apps, Facebook, Google, and we rated them on 5 different criteria on how they deal with censorship requests. Do they give users notice and an opportunity to appeal takedown requests? Do they limit the geographic scope of takedown requests? Do they disclose all of their takedown requests, both legal and policy takedown requests? Some companies did real well. As you can see here on the little excerpt that's on your screen, Apple gives users the rights that essentially that we ask them to. Facebook, however, doesn't. Facebook allows appeals only in certain very limited contexts. They provide notice in only certain contexts. Instagram, obviously, the same as Facebook. So these are essentially the companies that respect free expression more than others. Facebook did very poorly, and then if you go down, you'll see that YouTube actually did well. So it's an interesting look. And doing this in the post-Charlottesville era was very illuminating.
Yeah, absolutely. So if you're curious about where these companies fall on these issues, EFF has done the hard work, and you should go check that out. You should also check out the Coders' Rights Project. If you are a coder, what are you going to learn there, Nate?
The Coders' Rights Project is something that I run with my colleagues Kurt and Andrew and my colleague Jamie. And the four of us, all of us, we're all lawyers. We give free legal advice to hackers, developers, academics, researchers, you name it, who have either a research plan that they have questions about, or who have done research and have questions about their results. We can help with vulnerability reporting. We can help you craft a conference presentation or a paper that presents your research in a way that doesn't get you in trouble. And we work in the security research community to help build awareness of computer crime law, both in ways that they can avoid running afoul of it, and in ways that they can lobby their Congress critters to help make computer crime law less of a chilling effect on security research.
Right. I assume a lot of this has to do with navigating the turbulent waters of the Computer Fraud and Abuse Act.
Computer Fraud and Abuse Act, the Wiretap Act, the Stored Communications Act, the DMCA are the big ones that we deal with on a regular basis.
Great. And I would be remiss as we're giving out these great resources that EFF makes available if I did not encourage you to go on over there to supporters.eff.org/donate. That's how you can support their work. They also have a great store at EFF with wonderful swag and things. If you want to purchase some of their things, that also, of course, supports EFF's good work. I haven't yet put in our second MCLE passphrase. It's going to be Getty Images in honor of our first tip of the week. That tip is how to troll awards show photographers. There is a comedian named Emily Heller who attended the Emmys, and she attended with a gray handbag emblazoned with the Getty Images logo. That was just delightful for, I'm sure, all the Getty Images photographers, and not so much for everyone else taking her picture on the red carpet there at the Emmys. And I just thought it was hilarious and a very funny way to do some commentary on copyright law and licensing and stock photos in general. Stefan, did you see this?
I did. I love celebrity gossip, so of course I saw this.
Yes. I think it's the Fast Company called it a funny life hack to ensure she got photographed at the Emmys. At least the Getty Images photographers sought her out and took her picture. And then our second tip of the week takes effect today, actually. If you would like to do a freeze on your credit, we're a little over a year after the Equifax breach of last year, credit freezes are now fee-free starting today. So this is a good idea. It makes it harder for people to steal your identity. Maybe you could tell us some more about this, Nate?
Oh, I actually didn't. I didn't get this far.
Oh, okay. No, I just thought that maybe this was something you were paying attention to. Yeah. And maybe so. This is a good tip for you too. As of today, if you would like to put a freeze on your credit, which let's see what Brian Krebs has to say about this. Has for many years urged readers to freeze their files with the big three bureaus, as well as a distant fourth, Innovis, and the NCTUE, which is an Equifax-operated credit checking clearinghouse. So the reason you might want to freeze your credit is because it restricts access to your credit file, making it more difficult for identity thieves to open new accounts in your name. So this is something a lot of people did in the wake of the Equifax breach. Maybe you had to pay for it. But as of today, a law takes effect that makes freezing your credit fee-free. So I'm sure if you cruise around, you will find portals. Let's make sure they're safe ones to institute a fee-free freeze on your credit if you think that would be a good idea. And then finally, we have for you our animal selfie of the week. Our animal selfie of the week involves Tony Alsop, who is a gentleman who I guess rescued some animals in the wake of Hurricane Harvey and is now doing the same thing for Florence-afflicted animals in animal shelters in that hurricane's path. He got himself a school bus, and he set out from, I think, Greenback, Tennessee is from where he's from. And he removed the seats from the bus. And there is his selfie. If you are watching our video, there's actually a video he took of himself with all the animals behind him. These were animals that were having trouble getting rescued from shelters in places like North Carolina. And they're the hard case ones that nobody wanted to take out of the shelters. So he went through and I think is still engaged in doing this. So Tony Alsop is definitely worthy of our thanks and acclaim and recognition as our animal selfie of the week. And in fact, he has there are several. There's at least one GoFundMe for him, and he actually has a direct PayPal link, paypal.me/TEARSORG, if you want to donate to him directly to support his efforts. And of course, we do these animal selfies each week because of the fun philosophical legal question of if Tony had not taken this picture of himself, or if this camera that had taken the video of Tony was perhaps mounted in the front of his bus and set to some sort of automatic setting to capture him and the animals, who would have the rights to those videos and images? There have been various lawsuits that have thought that the animals did. So constantly seeking out and finding new animal selfies where we could ponder who owns the rights. Here, I think it's pretty clearly Tony. Matt, do you have any dispute with that?
No, I think Tony's got it, and what a cool guy, and it seems like he spent his time well in getting these animals. Absolutely. All right, guys, we are past our allotted time for the show. Believe it or not, time flies. It's been such a great discussion. Wonderful to have you back on the show, Nate Cardozo.
Thanks for having me.
It's been a pleasure. Of course, we've plugged EFF quite a few times, but are there any particular events or things that EFF is involved in currently that you want to highlight for folks before we sign off?
So as always, I want to plug our Surveillance Self-Defense Guide, ssd.eff.org, to teach you how to do OPSEC better than Paul Manafort.
There we go. Thank you for that. I'm sure we all appreciate it. What I really appreciate is the opportunity to have this great discussion with all three of you here today. Thank you so much, Stefan Spida, for joining us today.
Thank you. Learned a lot. Really interesting discussion. Appreciate it.
Very interesting indeed. And Matt Curtis, wonderful to see you too.
Yeah, great to see you. And thanks so much for being on, Nate. I didn't expect the Australian premiere, but I'm glad that we got it.
Absolutely. All right. If you have joined us right around 11 o'clock Pacific time, 1800 UTC, that means you joined us live. Thanks for doing that. We definitely appreciate having a live audience join us while we record the shows. Folks jump into irc.twit.tv, our chat room, and play along with us live. That's great fun for us. We really appreciate all the folks who contribute to the show that way, but don't worry about it if you can't join us live. If you head on over to twit.tv/TWiL, our entire archive of shows is there for you, and this show will be there too, just as soon as we can get it up there for you. What else shall I tell you? You should get in touch with us between the shows, please. You can email me. I'm Denise@twit.tv. Stefan Schweida, just email me and I'll pass it on to Stefan. We're still trying to iron out Stefan's email difficulties. But Matt is mattc@twit.tv. But we're all on Twitter. You can find us there. We have not deleted our Twitter accounts. We are trying not to fight with people there, doing our darndest. So you can reach out to us there. That's a great way too, as you are consuming your own possibly life-enhancing social media diet, to let us know things that you have stumbled across that you think would be good fodder for the show, people we should talk to or do more exploration of. Let us know who you think we should have on the show as guests, topics you think we should pursue, and what you thought of what we discussed today. We'd love to hear from you. In fact, we couldn't do this show without you. So we really, really do appreciate your input and insights. And with that, we'll go ahead and wrap it up till next week. Until then, take care.